So the intention is that our resource partners have, you know, they put their expertise on the table and they host these launch and learns for all of our portfolio companies. And ironically, we have all portfolio companies in the room. So anyways, this is Doug Kim. He works as an IP attorney for McNair Law Firm. And he's out of the Greenville office, but he obviously works with, you know, works with all of our companies statewide. So, Doug, we have, I think, 41 minutes now. Sorry, that was a long introduction. But anyways, the floor is yours. So we'll do about 30 minutes of Doug's presentation and then about 11 minutes of Q&A. Or if you want to do Q&A throughout, that is up to you. But anyways, welcome. Thank you for having us. And this is being recorded again.
Fair enough. Yeah, please, if you have questions at any point in time, just please ask them. It's informal, so there's no need to wait till the end if you have questions. I have about 75 minutes worth of material, so we're going to do this at a quite fast clip.
You're building ready to play.
By the way, that's how it works. So, what I wanted to talk about today was what trademark litigation is on the rise. A little bit about me, Davidson College graduate, Campbell Law School, because I wanted to become a prosecutor and front drug dealers in jail. Apparently, when you actually are becoming, you really work in the U.S. Attorney's Office. It's not like LA Law or Mine and Vice. So I got out of that. I discovered intellectual property. I did litigation for almost a decade, and these are the courts I was admitted in. So I had to specifically be admitted in all these courts, North and South Carolina, Federal Circuit, U.S. Supreme Court. Spent a lot of time litigating East Coast, West Coast, and then decided in 2008, you might have remembered that year, that I got out of litigation and got back into transactions. So I've seen both sides of it. And my opinion is if you're doing a lot of the transactions, then what you're really, if you haven't litigated, then you only do transactions a certain way. When we write patents, copyright applications, trademark applications, et cetera, knowing how they work in the courtroom is actually very helpful. So that's my background. The nice part about intellectual property, we can use 4 books in the U.S. Code, patents, copyrights, and trademarks. It's a wall of shelves. I only need 3 books, and there's an index at the end I use. So that's me. Patents are just that. Anything that's new, copyrights are what you think, books, we're not going to talk about those. Trade secrets, the crux is stuff you just keep secret. That's really the intellectual property aspects we're not going to talk about today. We're going to talk about trademarks. So what's a trademark? It is really just something that's used to designate the origin of something. Contrary to popular belief, the rights for trademarks are designed to protect consumers, not the trademark owner. So I'll explain that for a minute. As what we decided as a country philosophically is that when I walk into a grocery store and I see an orange box of detergent, I have an expectation of the quality and the source of where it comes from. And we protect that for the consumer because we don't want to confuse consumers. We protect that by giving the product maker the right to sue other people or to stop other people from using confusingly similar colors, names, brands. So it's this relationship the trademark owner has with the consumer public. So trademark laws are all designed to protect you guys. We just use the trademark owners to do that. Coca-Cola is a famous one. Apple's a famous one. These are famous marks, and it's hard to really decide what you can do without those. These are registrations. The Coca-Cola registration was 1928, so these things last as long as you're still using them, which is different. Copyrights have a term. Patents have a term. Trademarks do not. They can go on for a very long time. And believe it or not, since 1928, that Coca-Cola script has looked the same. They've had brand consistency like very few other companies have ever done. Apple's changed a lot. By the way, I really wish I was sitting in the meeting when they came up with their name. Can you imagine how this goes? We're going to create a new computer. It's going to have this little thing in the front that you do and you point on the screen. We're going to call it a mouse. Okay. What do you want to name our company? Well, I don't know. How about IBM's out there, Digital's out there, Beck's out there. Hey, let's call it Apple.
But something to do with where it was in the phone book?
It could be. Yeah. No, then it would have been Aardvark. But no, I mean, and if you recall what's happened to Apple's, contrary to code, their brands changed, their logos changed. It used to be Apple Computing. Then it was an Apple with the rainbow, Apple Computing. Then they dropped computing, then they dropped Apple, then they dropped the color. So they've matured over the years and modernized their brand. That's what we usually see. Coca-Cola is a new situation. Trade names are just that. They're the name. Trademarks and trade names can be confused sometimes because the trade name is what you call your business. It's not necessarily a trademark. Just because you call your business something doesn't mean it's actually a mark. You guys have ever heard of Sunbeam, right? The company that owns Sunbeam is called Fortune Brands. Nothing to do with their trademarks. We have a lot of confusion sometimes in the marketplace, and this is one of the areas we're seeing less of it, which is good. People they get their company organized, LLC or an Inc. The South Carolina Secretary of State says the name's available. That doesn't mean you can use the name. That just means the corporate name's available in the South Carolina Secretary of State. It has nothing to do with the ability to use it from a trademark standpoint. We're starting to see some of those issues go away. It used to be pretty bad.
Wait, can you say that again?
Sure.
Yeah.
If I decided to go to the South Carolina Secretary of State, I could probably get the name Doug-Nike, LLC. The South Carolina Secretary of State will probably say that name's available. You can call your company that. If I ever decided to try to start using Doug-Nike in the world, I'm fairly confident within a matter of weeks I would get a letter. Okay. Because the corporate name doesn't have anything to do with the trademark side of it. Right? So whenever you register your company name or attorney says the name's clear, the corporate name is available in the Secretary of State's office, not available to be used in the world. It's a whole different process. It's gone so far as the Secretary of State for South Carolina on the bottom of the form when you file your company says this has nothing to do with trademarks. So it's actually on the form itself. So be aware of that. You're seeing less of that. This is a fascinating one. I don't know if you know this or not, but when Apple first started off, they got into a dispute with the Beatles, right? Because it was the Apple core. And this is going to sound crazy, but if you look at the timeline, 78, 98, Beatles sues Apple. They settled the case with Apple saying, we'll never have anything to do with music. 86, 89, Apple adds MIDI. What MIDI is it's an interface that you can connect musical instruments together. That really didn't help the Apple core very much, so they sued them again. In 1991, Apple and the Beatles settled again, and Apple said, we won't do any music. In 2003, 2006, iTunes gets released. Shocker, another lawsuit. 2007, they settled a case where Apple Computing licenses to Apple Core, because the Beatles at that point had really lost a lot of assets, shall we say. It was Apple Computing was a monstrosity at that point for the company. 2010, the Beatles songs were released on iTunes. So we have really come full circle on this one. And if you recall, this is hard for me to believe, 2007 is when the iPhone was released. The iPhones are only 10 years old. Isn't that crazy? So anyway, this is the interaction. If you look at the two logos, this was sufficient enough for the two to have a dispute. So this is not a side-by-side comparison. This is can someone look at the Apple Core and the Apple Music and say that's a problem? My understanding was that this was sort of a love-hate relationship. They would agree and then fight and agree and then fight for 20 years. Fascinating story, though. Service marks are just that. They mean you're providing a service, not a good. There's a distinction in the world with the way they behave, but for purposes of today, just know technically we use the word trademark to describe. Informally, we use the trademark to describe both. Technically, there is a trademark and a service mark. Law firms provide services. BMW provides a good. So that's the difference with a trademark service mark. Certification mark, these can be very powerful based on your industry. If you're sort of a standard setter, a certification mark can be something you can obtain and say, gosh, if it's got this mark on it, it represents something to the universe. The difference with the certification mark is that by being a certification mark owner, you're specifically saying, we're not going to use it. We're going to authorize other people to use it. So it's a little bit of a different animal. I've seen these become powerful when there is a piece of technology or something out there that is very desirable and people want to go with Intel Inside, UL, good seal of good housekeeping. That's when they're pretty powerful marks. But you've kind of got to be an industry setter to really get to that level. But that is when we talk about trademarks, we are talking about this. South Carolina trademark and service marks, they define, pretty much follow the federal rules. We'll ignore this for right now, but when I'm talking about trademarks and service marks, I'm going to include federal and state. We'll look at the differences in just a minute. You have to use them in commerce. The key to trademark rights is use. There's one way to reserve a name for a short period of time, but for the most part, trademarks have to be used. I can't just say I would like to, I can't come up with names. I can't just say I would like to have, Doug's computers. I have to go sell a product, start a business, put a service out in the world. Use is key to all these rights. All right, so let's look at litigation trends. I did this until October 29th. That's when I put these slides together. Real quick, patent litigation from 2008 to 2017 is on the decline. So explain this chart a little bit. The red bar are the number of cases filed in that year. The greenish bar are the number of cases that were closed, which usually means settled 90+% of the time. The purple bar is the ones that were pending. Because if you think about the timing, if it opens in one year and closes in another year, you can get some weird data if you don't look at the pending numbers. The trend line is the number of cases pending. So if we look at patents, we can say about 2012, the number of patent filings was on the decline. The number of cases being closed, generally on the decline, but slightly less. The number of cases pending, definitely on the decline. So what that says is we're filing less and we're settling more. We're getting the patent cases out of the courts. Okay. This is the number of patents being filed, though. If you look at the number of patents being filed for the same period of time with at least one South Carolina inventor, it's on a slight rise. Applications filed, applications granted. So we're seeing a slight rise in patent applications filed. We don't have the 2016 was incomplete, 2017 data I obviously don't have yet. But from what we're seeing, 2017 is that it's going to be a spike. We feel like 2016 there was a lot of pent-up activity. In 2017, it was released. I can tell you personally, the number of applications I filed this year is twice that of last year. So something was going on in 2016.
So is that all applications or provisionals and bona fides, or how?
This would have been utilities, which would have been provisionals, designs, and non-provisionals, right? It would not have been all applications, yes. And we can break that down if you're interested. But honestly, the difference between the provisionals and the non-provisionals kind of skews this a little bit. So what do I mean by that? An application is not published for 18 months. So you're really looking at, when we see 16 and 17 down, they're just now coming out. If that makes sense. There's that 18-month lag we have. That's why you're going to see a spike in 2017.
Doug, can I also ask a question?
Sure.
I mean, you've got South Carolina patent grants here. We fall with the USPTO.
Correct.
So are you just distinguishing just South Carolina here, or is this kind of a overall with the U.S.?
This is the patent applications filed in the U.S. Patent Office that had at least one inventor who was shown as being a South Carolina.
Okay. So how does that compare, I guess, with respect to your statements here on South Carolina with across the U.S.?
Nationally, it's a higher peak. It's a higher grant. Nationally, the applications look more than that. South Carolina's not filing as many. Yeah, and what did happen, at least year to date, was something interesting. Usually you see Milliken or GE as the top filers. That's just what happens every year. Individual inventors are like 2, 3, or 4 in the list, and they're usually a large number. As of October 29th, individual inventors were the #1 filers. So what that tells me is either you're not assigning your patents to anybody, or that there's a lot of individual activity going on. And in all fairness, I've not dug into that data yet. I usually wait till January for that. But generally, the trend's up.
Have you talked to Jim Watson with the SBA about this? He's doing a report for the Navy in their SBIR program. He needs data like this to support, funding for SBIRs. He's looking for patent applications.
Oh, I'd be happy to. This is not hard to get.
It's a national report he's putting together.
Yeah, it's not hard to get. Yeah. With the caveat being, I've got an 18-month problem because 2016, I'm just now starting. I got 2 months left of data that's not coming in. So I think you're going to see a peak. Filing trend without 2016, which we ignore, you can see is up. That's why I say this is going to be higher. All right, copyright cases. This is litigation now. What do we see? General same idea. I won't mention his name, but there's an individual in Greenville who is an architect who's probably responsible for 40% of these. Okay. So I've not normalized the data and taken him out yet, but with that said, though, we're talking, other than 2008, which was that individual, you're looking at 10 cases, 5 cases, 6 cases a year. So copyright cases are not that big a deal in South Carolina. This is where the story gets interesting. So what we see in South Carolina with trademarks, we see a clear rise in the number of cases that are being filed. We're seeing, while we have the same rise in the number of cases being closed, the tendency is rising. So what that tells me is we're filing more trademark cases, and they're hanging out in the courts longer. Okay, so what does that mean? We're fighting more, both in initial filings as well as that. I've not done it yet, but the next thing I'm going to start doing is going there and digging in and saying, all right, what are all these cases about? Are they outside entities suing our South Carolina companies? Are there South Carolina companies suing South Carolina companies? Are they South Carolina companies suing outside companies? That will come January-ish when I see that. I'm very curious to see what that looks like. So when I started seeing this, I started going back and saying, all right, I looked at a handful of the cases and I said, what's going on? And what we found out was there's a handful of areas that are causing this to happen, in my opinion. First one is this. People have, for the most part, either don't know, or not doing, or choosing not to do this, but they're not performing a trademark search. Okay, and I don't, I'm not getting that. There's what trademark searches can do for you is a handful of things. Can I get my mark registered in the USPTO? That's one of the first things it does. Is there anybody out there that's got an application, a pending application or registration that might be a hurdle? So the first thing it does for me is it says, all right, if I file an application, what are my chances? What am I going to run into? You know, experienced trademark attorneys can look at a search and give you a pretty good idea of what's going to happen. You know, I can, almost 20 years of doing this, I can tell you, we're probably right 90, 95% of the time. There's oddballs every once in a while that show up. You know, I can describe some of them, but one of them was a custom software company with a certain name, got a demand letter, got a rejection in the trademark office and a demand letter by another company with the same name that made ballistic software to go in military scopes. I would not have looked at a search and said, oh, that's a problem, but it was. Okay, we solved it and everything was fine. We missed them every once in a while. I don't see it coming. The only other one that didn't get me by surprise was a name for satellites was perceived to be in conflict with a name for rabbit ears on a television. Wow. Yeah, okay. So I mean, there's oddballs every once in a while. So general rule, if it's anything from Mattel, anything from Callaway Golf, anything with the Red Cross, just stay away. They are very aggressive in their pursuits. They really are. As entities, that is their strategy. And I've run into them more than once for the time. But we get this feel. Certain industries have certain areas we learn about. If you're in the financial industry, the difference between the marks are very small. First Commerce Chase, Chase Commerce First. All of those are very similar. When we get into the consumer goods, consumer electronics, the gaps are pretty large. They get large. Firearm industry, gaps pretty small. You know, golf industry, got to be pretty far away from your competitors. So we kind of get a feel for industry information too, but that's experience on it. The other thing it can do for you is get you a potential risk of infringement, which we will talk about at some length. If you do a search and somebody out there has a similar mark, you can actually say, oh, they're based in Montana. An issue, not an issue. We'll talk about that later. Hey, there's a company in North Carolina with the same name doing something similar. Wow, maybe I should reconsider my name. So it can help you not just with registration, but it can help you at least analyze potential risk for infringement from a third party. And then competitive goods and services. Searches can be used kind of proactively to be able to say, I could tell you right now, what did Michelin file in the past 6 months? These names for these products. Oh, this is the direction they're heading in. You know, so it can be used kind of market research to see what competition you've got out there.
Once the certification is given for your trademark, can you still be sued?
You can. Well, we can. It becomes a timing issue, and I've got 4 or 5 slides that I hope are not confusing because the timing issues are challenging, and we'll talk about that. But the answer is yes, you can. It is not a defense. It's a right. When you don't perform a search, this is interesting, Amazon shop Fast Draw USA. So Fast Draw USA comes out, company introduces a product line with Fast Draw USA, they make holsters. Says files the application for holsters, rifle mounts, firearm attachments, mobile gun mounts. So there's another company who has this registration for Fast Draw. Okay, so if you were the company that came out with Fast Draw USA, and then you didn't know about this company that's called Fast Draw, what ends up happening? Well, this company files an application. There's no question they didn't do a search, in my mind. This was the registration used to reject the first company's application. My product's out the door on Amazon. I have an application filed after somebody else has a registration. I've pretty much just handed this company the lawsuit, right? I mean, this is sort of when it all goes bad, right? So the first company would have been better off not filing the application, but having not done a search, they didn't know not to do that, right? So that's where it goes bad. Not performing the search has really been damaging. Defendant's failure to conduct a trademark search prior to commencing use of the mark qualified as intentional blindness, which gave the court the ability to say, you're a bad faith infringer. That's an extreme case, in my opinion. It sounds to me like if you go back and you looked at that particular case, there was a bad guy there. That's a court going out of its way to pop somebody. When you hear the bad faith analysis, you hear attorney fees, triple damages. So that bad faith is bad. So but not doing the search was bad. This one, Massachusetts, defendant acted in blind disregard when it refused to follow its counsel's advice. Good lawyer. Obtain a trademark search and opinion. And if you tell us you don't want to pay for a search, you'll get a letter that says, thank you so much. You've told us not to do a search. We are going to, we'll proceed anyway, but understand there's risk. You know, that is something we have to do because of these cases. Owen Corning. Owen Corning is the only company that can make insulation color.
Really?
What trademark is a color? The Home Depot color. We've heard that that's.
Yeah, their color is that it's retail store services in the construction and lumber industry, so it's pretty narrow goods and services. So it's
Bill Needle, wasn't it? Bill Needle.
Excuse me?
Didn't Bill Needle from Needle?
Yeah, I'm not sure. Harley Davidson attempted to register the sound of a Harley.
Yeah.
Failed. Total failure. I'm disappointed the trademark office was given that. My running joke was I have this mental image in my head of this mountain of original exhaust pipes somewhere in the country. What's the first page of the book say? Remove exhaust system, install straight pipes. All right, yeah, okay. All right, you're using your mark in Charleston. You have a registration. You get a registration. Someone else uses the mark in California after you file your application before you get your registration. So you use it first and you file an application first at the federal level. You can stop them, but only after you entered their market. So once you open up that store in LA, you can give them a phone call and say, hey, I filed my application before you started using yours. When are you going to change your name? That's what the federal rights do for you. They give you this nationwide protection that lets you stop people. Well, you have to penetrate your market. And the reason for what we call it market penetration is if we're trying to protect the consumer, and these two people from Charleston and California don't have the same consumers, there's not a problem. That's why we require you to have similar consumers. That's what this market penetration is about.
What if you marketed to folks around the country through trade shows, and they have, folks in your industry have seen your logo?
Mm-hmm. Yeah, you at that point, you're probably okay with that because while you've not made a sale, you're engaged in point of sale activity, which is different than just putting up a website, right? You're taking specific actions to travel to and attend physical locations for us, right? So while you don't have a sale, it's more than a website. Okay. Same is true. You use your mark in Charleston, you file an application that registers. Somebody else is in California, but they started using it before you filed your application. If that's the case, you can stop their expansion. You cannot prevent them from their use. They got rights from use, and their rights existed before you filed the application. What the federal system does for you, it says, gosh, I can't stop you in LA, but you're not going outside of LA and a little bit very outside of that. So the federal system gives you a lot of rights, even when someone used it before you, as long as the California people didn't have the registration before you, which is this example. Same thing works in reverse. They can lock you down here. So if you do a search and the search is clear and you think you're going to go national at all, it makes some sense to file an application, the grander list. With one class, we can get into that detail. So we're not talking about a tremendous amount of money when we're talking about these types of businesses. Where the applications for the federal system doesn't seem to apply is if you're, and we see people do this anyway, my subdivision. Developers seem to be registering federally the name of the subdivision. Pretty sure, now if it's the Cliffs, I get it. That is national presence. Where I live, we live across the street from rich people. You know, our neighborhoods, that's probably not important. But so there are some circumstances when the federal protection is not necessarily needed. But if you have any desires or wishes at all to go more than one state, it makes a lot of sense. If you ever have any idea, if you ever want to exit, or you ever want to have any type of acquisition or anything like that, it's one of the check boxes people have, and they just take it off the table. Do you have a federal registration? Yes, check, next issue. You know, so this is just not a big deal. I don't get it. So that's the second thing. First, not doing a search. Second, not really fully understanding the benefits and detriments of the federal registration system. And the third process is not understanding the strengths of marks. This is amazing to me. So fanciful are the best marks. There is Exxon and Menageries. Menageries is a friend of mine. She has an interior design business. The word came from panache and menagerie. She mashed them together. It's not a real word. They tend to be the strongest words. They tend to be the most protectable. They tend to win lawsuits a lot. And they also, just because of the very nature of their creation, you don't find a lot of competitors using the same name. Arbitrary, it's an existing word, but you're using it for something different. Apple, right? Apple Computers is not an Apple. Well, it is now, but it wasn't when they first did it. Nova, gaming company here in Greenville, that's bought by an Australian company, did really well. Nova is an existing word, but was never used for gaming company before. That's arbitrary. Suggestive, copper tone, feed a pit, local few. Local few has a full tables, imagine that, right? So these are good, but right in the middle of the pack. For some reason, this is where everybody hangs out. Shoe land for shoe stores. Here's all I got to tell you. If you're called Epic Buffet, it better be good. But what do we see? We really, for some reason, we see a lot of companies wanting to name themselves down here in this descriptive, suggestive area. The higher you can get up, and then the higher you can get up here, the better you're going for that. The last one's generic, China Buffet. It's China Buffet. So these are not protectable, not registerable. An interesting thing that can happen if you don't police your mark, you don't stop people. If you're super, super successful, but you don't stop other people from using your name and you become a household name, you can go from up here to generic. Dry ice, escalator, brazier. Q-tip almost went there, but now you can buy a Q-tip from Johnson & Johnson, or you can buy a cotton swab from everybody else. You can buy a Kleenex or tissue. So you can do it. In fact, Xerox had a little bit of trouble because if you recall, those of us who are old enough to remember this, I would go make a Xerox. I did not go make a copy. Well, they had to do some advertising and marketing and send some letters and police their name to keep it from going generic. That means you've done a really good job if people start using your name as a household word. Don't know why people hang out here. Please try to get up here when you're doing marketing stuff. And I won't name names, but there's a couple of marketing companies in town that hang out here, and I'm like, you know, up here. Right. The stronger the mark, the better you are up here. The higher you can get up on this chain, the better off you're going to be. The villages, I'll do this one real quick. Registered in 2000, first use in 99. Real estate brokerage of residential housing, subdivision. Okay. The villages is the name. Real estate brokerage housing. Not understanding the strengths of the mark, this company, they had these registrations all called the villages. These were all their registrations. So they had 5 federal registrations for the villages. They were here. Okay, 12 minutes away, 6.8 miles, Villages of Lakeside Landing starts. I've got 5 registrations. I started in 1992. You are 7 miles away. You started in 2004. Villages with the registration sue these people. Okay? The concept being, if I'm going to go buy a house at the Villages, I might accidentally go to the Villages. Right? From what you know right now, who should win? Bottom guys, right? 6 months away. What the court said was, Villages widely used in Florida, it's weak, it affords only a narrow rate of protection. Villages could not show it was likely to succeed on the merits. It lost the preliminary injunction because the strength of the mark was bad. Remember I said, get near the top? Okay. So that was you came out of the gate wrong, according to the court. You know, now ultimately they settled it. Villages of Lakeside Landing changed their name to Lakeside Landing, but that was out of politeness.
Yeah. But the one up 12 miles north couldn't use that script version, right? So they could use the name, but they couldn't imitate the fancy script.
No, the court said, the lower people went to the court and said, I need you to tell them to stop, and the court said, I'm not convinced you're going to win. I'm not going to do that.
So they could have even copied the script.
Yeah.
Wow.
Yeah, but the court didn't get to that, so probably not. The court didn't get to that. It was looking at the name of the village. Right. So anyway, there's my top 3. Trademark attorney, proper search. Understand geographic areas, federal registrations, and understand how to do strong marks, get near the top. There you go. And I have, a minute left.
Quick question on, you got U.S. How about U.S.? How about foreign? I mean, international. Should you pursue that?
That's a whole 45 minutes.
Yeah,
45
okay.
minutes. The answer is, again, typical attorney answer, it depends. So what we generally tell people is foreign marks are really, the cost is about the same per country with the exception of the European Union. I can file an EU mark, and that will protect me in all the EU countries. With the caveat, I'm not sure what's going to happen with the UK because of Brexit. Right? So every client who comes in, I'm saying, we can file directly in the UK and the European Union, belt and suspenders. More than likely, the European Union and the UK are going to have some kind of agreement to where the UK will honor EU marks that are existing as of the breakup. The EU and the UK are not getting along right now, so I'm not real sure that will happen. So I don't know. That's that issue. The decision is a business decision. It's a risk-reward decision. If you feel like you're going to have your products or goods or services in a country, it's a good idea to do that. Each country has its own weirdness. In China, you should file the mark in English and Mandarin. And I can get into the Michael Jordan case for that. Michael Jordan was told that he could protect the name in English, but could not do it with the Mandarin translation because his application only said Jordan. I don't have that exactly right, but there was a translation issue in that case. Foreign translations you got to be careful. The most famous being the vehicle Nova. When they tried to use that name in Mexico, won't go. Names don't go. So there's issues with foreign. The best answer is if you're going to be in a country with sufficient activity to warrant it, it's not that expensive. We have to look at what country you're going to or countries and say this makes sense. There's a company in town that has 30% of their businesses in Europe. They hold trademark registrations in Belgium, and the countries where their product is well received. So that's what it is.
So Doug, in the case of generic names, like for proper names commonly used, we've run into that recently. So would your lawyerly advice be to modify the name or to wait until there's enough business surrounding it to make it unique?
The cheapest time to change a name is now, right? Because the farther I get down the path, the more goodwill I build up, the more collateral material I have, the more customers that know me, the more contracts I have out the door, the more product on the street, the harder the name changes. So the cheapest change of name is now. So that's answer number one again. Another component of that answer is that this is kind of a marketing play. If the purpose of a trademark is to identify the source of the goods or the services, and you're calling yourself China Buffet, what are you doing? You're not, from a marketing standpoint, it has little to no value. So if a brand needs to be your signature out into the world that says, this is me, this is my name, this is who I am. When you see this name, color, logo, or whatever, identify my goods or services with me. buy them from me. So that's the second component. The generic ones, what you're saying is that I'm willing to reduce my risk of having an infringement problem because it's not a protectable name. In exchange for that, I'm going to undermine my ability to successfully brand or market and distinguish myself from competitors. So you're kind of trading that off.
So one other question. So complicating it by having sub-product names underneath, like Johnson and Johnson's, water, for example. Is that a helpful thing, and does all that turn into a registration?
It sure can. There's something called a house mark strategy, and the automotive industry does it very well. The Honda is the house mark, Honda Accord, Honda Civic, right? The Honda Pilot. So they use this house brand, and then they have these sub-brands, which are their own brands, but they're generally tied to the house mark, right? So they have that. So that is a branding strategy that should be driven by your marketing company. You should not let the law drive that, right? So
Yeah.
there's the point. Yes, it does help, but it's a product strategy.
Yeah.
Johnson & Johnson is such a strong name; they like tying it to all their different products. Fortune brands went the other route. Sunbeam, Maytag are not connected together like Fortune brands. They're standalone brands. Our tool company in Anderson has decided to not use the house brand. Ryobi, Milwaukee. They decided it from a business marketing standpoint. Milwaukee is perceived to be a higher quality product, so they wanted to not tie it together with Ryobi, which is a Home Depot product. So it's all branding and marketing strategy. More questions? Thank you very much.
Thank you.
Thank you.
You guys are welcome to these slides.
Yes, you come. So that's why you get goofy names like Hulu.